must go! Anita must go!
Some of the over 100 people who were arrested, charged and remanded to Luzira prison following their participation in recent anti-corruption protests were charged with the offense of being idle and disorderly and common nuisance.
They've been released on bail.
Despite the Constitutional Court nullifying the section of the Penal Code relating to the offense of being idle and disorderly in 2022, the revised 7th edition of the Principal Laws of Uganda still lists the offense along with that of common nuisance. In an exclusive interview with Nation Media Group, the Director of Public Prosecutions, Frances Abodo, has admitted that some of these laws are archaic.
Our laws, most of our laws, we inherited them from our colonial master. And a number of them actually need cleaning up. A number of them, if you look through the Penal Code Act, a number of laws really are archaic.
For Abodo, the reason for the continued preference for the charges of idle and disorderly or common nuisance is simple. They still exist in the law books.
This is still there, so Parliament has to do its work and remove them from the law books. Otherwise, as it is there, I don't think my office should not come under so much attack that we are actually charging, because we are not charging with those existing laws.
Abodo has also provided clarification on the Constitutional Court's ruling regarding the offense of being idle and disorderly.
Constitutional reference, I think 36 of 2018, where the people are referring to that the idle and disorderly was actually outlawed. It wasn't part of it. It was saved, and it is still there up to now. Up to this morning, I found it still there.
Abodo adds that with the current status quo, the hands of the Director of Public Prosecutions are tied, and changes will only be effected when Parliament repeals these provisions. However, she mentions that there are administrative measures in place that consider public concerns about these laws.
When there was that outcry, we recalled the files and looked at them, and we agreed that the law is there, but we can remove it as we wait for Parliament actually to outlaw it. Administratively, we removed the idle and disorderly charges, and we left the common nuisance charges.
She says the protesters arraigned before the Nakawa court about a fortnight ago should never have been charged with being idle and disorderly.
If they were only charged with that offense, definitely they go off, yes.
So has that been communicated to court?
Yes, we even put in an amended charge sheet already last week. Yes, in Nakawa, because it was only in Nakawa where it was charged.
Despite the general agreement that these laws are obsolete and archaic, they can technically still be applied until they are repealed. In the recent past, amidst calls for omnibus constitutional and electoral reforms, the government has cited a lack of resources to facilitate the process.
It's not just that, people are just demonstrating peacefully. It is not that.